Hello everyone, welcome to JAIIB CIB Prep. In today's video, we'll cover unit number 4, opening account of various types of customers. In this particular video, we'll understand about personal accounts, accounts of individual, joint account holder, account of illiterate person, account of blind person. We'll move forward to accounts of other customers like HUF, sole proprietorship, partnership firm, LLP, company, trust, cooperative societies. Will look into norms for opening current accounts, obtaining photograph of account holders, legal entity identifier, and then we'll move forward to our practice question. So without further ado, let's start our video. Now, as a banker, you deal with various types of customers like individuals, companies, partnership firms, and cooperative societies. Each type of customer is governed by different rules and laws. For example, while dealing with individuals, Indian Contract Act come into picture. While dealing with Partnership Firm, Partnership Act, LLP Act, Companies Act, so on and so forth. So when a bank opens an account, it must follow the law applicable to that specific customer type. What is an account opening form? When a person wants to open an account, they fill out an account opening form. This form collects basic details like name, address, how the account will be operated, customer's declaration. Think of it like a contract between the bank and the customer. And KYC, we have already learned about KYC. Bank must follow KYC rules. They take ID proof, address proof, and other documents. They also fill out a special form called CKYCR form used for both individual and businesses. Let's move forward to personal accounts now. Personal accounts, these are accounts in the name of one person or jointly with other. Who can open an individual account? A person who is of age of majority. A person who is above the 18 years of age can open an individual account. The person should be mentally sound and he should not be disqualified by law. When we say mentally sound or of sound mind, we means that the person is able to form rational judgment for him and see what is in his or her interest, and not disqualified by law, like he is not declared financially insolvent or bankrupt by the court of law. For example, if a person aged 30 wants to open a savings account, he can do so if he submits proper KYC document and signs the form. But if the person is a minor or of unsound mind, the account has to be opened by a guardian on their behalf, and the guardian's document are also needed. What are joint accounts? These are accounts opened by two or more persons together. When why it is opened? Why open a joint account? If a husband and wife wants equal access to family savings, if elderly parents want their son to help operate the account for easy access in case of one person dies. So, if they want to share joint control of funds or one person wants to give access to another, then joint account is opened. For example, there are two individuals, A and B, and they open a joint account, so either of them can withdraw money when needed. So their relationship and the purpose of joint account among the holders should be clear, and it should be clearly stated. All joint account holders must sign the form, submit the KYC documents, and clearly state who can operate the account. Like either one can sign or both must sign together. For example, if the sign of A or B can work, or there should be signatures of both A and B in order to operate the account. So this has to be clearly stated. What if one person is NRI? So in case one person is NRI, they must choose a close relative to open an joint account. Account of illiterate person. A person who cannot read or write is called illiterate person, but still they are allowed to open a bank account, but with special precautions. No one should take unfair or undue advantage of illiterate person. So proper rules have to be followed. Number one, bank staff must explain all account rules in a language the person understands. If he or she understands Hindi, then we cannot explain the rules to them in English. Or if they understand the rules, they understand Marathi language, then we cannot simply explain the rules to them in any other language like Malayalam or Hindi. We must make sure that the rules are explained to them in the language which they understand. No checkbook or current account is allowed for a illiterate person. No checkbook is given no matter what. Even if they operate the account jointly with a literate person, the checkbook will not be provided to them. The person must visit the bank personally to withdraw money each time with a passbook. Their left hand thumb impression is taken in front of a bank officer and a person who is known to them, who is a trusted witness. Uh, Two passport size photos are taken, one for the form and one for the passbook. They can authorize a literate person to operate the joint account to operate the account jointly with them, but we have to make sure that the mode of operation should be joint and not either or survivor basis. So a illiterate person, say name X, wants to open the account, he or she must come in person to withdraw the money. Now if Mr. X wants her son to help, then they must operate the account jointly. Operate the account jointly. Accounts of blind person. Blind persons are legally allowed to open the account, but again special care is required. So blind individuals can open a bank account. They must provide two passport size photos. Their signature or thumb impression must be verified by someone the bank trusts. If they face difficulty in signing, bank may take both signature and thumb impression. If the branch manager is satisfied, branch managers can allow them to operate the account themselves or let a trusted relative do it after proper authorization. All account entries must be read aloud to them during every visit, but it has to make sure that no other person can hear these transactions. For example, if Mr. A is blind, he wants to handle his account himself, the bank will read out his balance privately, and if his signature changes slightly, they will also use his thumb impression for security. Account of minor. Who is a minor? As per Indian Majority Act 1875, a person in India becomes a major at 18 years of age. So anyone below 18 years is called minor. If a person is of 17 years and say 150 days old, he is still a minor. He becomes a major the day he turns 18. And what does law says about minor and contracts? According to the Indian Contract Act, minor cannot enter into legal contracts. They are not competent to contract. This means a minor cannot buy or sell property, sign agreements, etc. However, there are some exceptions. A minor can receive money if someone gives, if they are for essential items. Uh, so a minor can receive money or gifts. If someone gives essential items to the minor, the contract is valid. For example, if bank provides loan for the necessity, then the loan will be valid, else it will not be valid. Can minor open bank accounts? Yes, minors can open bank accounts. But again, there are some rules and conditions. Number one, minors should be above 10 years of age. They must be literate. KYC documents of both minor and guardians are required, and date of birth must be clearly mentioned and recorded. Say Arav is 12 years old and can read and write. He can open his savings account in a bank, but again, with his guardian, who can be guardian. Father is usually the natural guardian, but RBI also allows mother as guardian, are not step parents. Step parents are not allowed. Also, two minors cannot open a joint account. So, two minors cannot open a joint account. Banks may provide ATMs, debit cards, and net banking, but no overdraft facility is allowed. meaning to say accounts cannot go into negative balance. For example, a child named Ria, 14 years old, gets a debit card from her bank. She can spend only the money available in her account. She cannot take loans or spend more than her balance. And what happens when minor turns 18? So guardian loses control of the account. Now the now major person must confirm the account balance, submit fresh signatures, and give new instructions. So these are some important legal provisions like no overdraft in minor's account. Number two, minor can sign a check as per section 26 of the Negotiable Instrument Act. On death of a minor, a guardian must close the account, and if guardian dies before the minor becomes major, money will be paid only after the minor turns 18. Hindu undivided family. A Hindu undivided family is a joint family setup where a business or property is passed down through generations. It includes a common ancestor and all his descendants, including daughters, since 2005. Now, who are the members? Uh, let me make you familiar with certain terms like co-partners. So, family members who share the property are known as co-partners. Karta is the head of the family, usually the eldest male, but eldest female can also be Karta now, and it was ruled by Delhi High Court in the case of Sujata Sharma versus Manu Gupta in the year 2015. So, what was the name of the case? It is Sujata Sharma versus Manu Gupta. Um, Imagine Mr. R runs a textile shop and he passes away. His two sons and one daughter now inherit the business. Now the shop becomes HUF business, and one of them, say the eldest son, can become the Karta. What are the rules for opening and operating HUF account? Uh, Karta can take loans and sign papers, but it's safer if all adult members sign the papers too. Declaration should be taken to confirm who is the Karta. Bank will not get into the part like who is the Karta. So a declaration should be taken from the HUF. Karta can sell property only if it is necessity for the family or business. Minor co-partners' name should be recorded. Their guardian signs for them, and if one member leaves the HUF, it does not close the HUF or the account. So these are the rules. What are the documents required? Account opening form should be signed by all adult members. Signature card should be signed by the Karta. Joint Hindu family letter should be signed by all adult members. Guardian signatures for minor members and KYC documents of all members are required. And who operates the HUF account? Normally only Karta operates the account, and some other cases other adult co-partners can be allowed to operate if needed. Sole proprietorship firm. A sole proprietorship is a business owned by one person. So there is no legal difference between owner and the business. A savings account cannot be opened in the name of proprietorship firm. Only a current account is allowed. Right? Keep that in mind. Only a current account is allowed. Rules for opening and operating sole proprietorship account. Only the proprietor signs all the documents. A declaration confirming ownership is needed. The proprietor signs in the name of the firm, and even checks must be signed as firm's name. What are the documents required? Current account opening form is required, which is signed by the proprietor. Signature card signed by the proprietor. Proprietorship declaration and KYC documents like PAN, Aadhaar card, business proof. These are required. What is a partnership? Partnership is when two or more people they come together to a business and agree to share profit. It has been defined under Section 4 of the Indian Partnership Act. Section 4 of the Indian Indian Partnership Act. This act is of 1932. Okay, so it has been defined under Section 4 of the Indian Partnership Act, and registration is optional, but it is compulsory in the state of Gujarat and Maharashtra. What are the rules for opening of a partnership firm's bank account? For registered firms, the bank must collect a copy of the registration certificate. Partners should sign on behalf of the firm and not in their personal capacity. Checks in the firm's name should go only to the firm's account, not to partner's personal account. If any partner raises a dispute like stopping the account, then all transactions must be stopped until all partners jointly agree to resume. Uh, there are some rules in case laws. So, every partner is considered as an agent of the firm. Even sleeping partners, they can be held responsible. It has been decided in the case of Abbas brothers versus Chetan Das Fateh Chand. And even if one partner manages everything, it's still a partnership. Okay, so it is still a partnership, and it has been decided in the case of KD Kamath and company versus CIT. What happens when new partner joins? So if a new partner joins, if the account has a credit balance, meaning to say the balance is in positive, it can continue. And if the account has a debit balance, say it has negative balance, then open a new account to prevent the confusion due to Clayton's rule. Now, what is Clayton's rule? So Clayton rule said that old debts get paid off first from the new deposits. What are the limitations and special situations? Let's talk about them. Our partner cannot be treated as an agent when dealing with other partners. For example, if two partners borrow money from the third partner, the other partners are not held responsible. And if a partner dies, the partnership ends automatically unless stated otherwise. Bank must stop operations, close the account, open new account under legal heir's name, and collect letter of administration from court. So if Mr. R dies, new account can be Mr. R deceased, and whatever the legal heirs or executor's name, say Ritesh. So Ritesh bracket administrator. No partner can open account in his own name, withdraw court cases, admit liability or sue in firm's name alone, buy or sell property in firm's name, and any partner can stop payment of a check issued to other partner. What happens when a partner retires? So when a partner retires, stop the bank account. You open a new account to ensure the retired partner is not liable for new transactions, and give public notice in newspaper to legally confirm retirement. What are the documents needed to open partnership firm account? So there are account opening forms signed by all the partners, specimen signature cards, partnership letter describing the business name and account operation rules, original and copy of partnership deed, registration certificate, instructions and specimen signature of authorized signatories, PAN of the firm, and KYC documents. Now let's talk about limited liability partnership. So what is an LLP? LLP is a mix of partnership and company. It is formed under LLP Act 2008. Now, as the name suggests, limited liability. So, partners here have limited liability and they are not personally responsible for the losses. Say, if a business loss is rupees 10 lakhs, a partner will only lose their share of investment and not personal assets. LLP must have at least two designated partners and they need a DPIN. A DPIN meaning to say designated partner identification number. there will be an LLP agreement which decides the roles and responsibilities. What are the rules for LLB bank accounts? So, a resolution by designated partner is needed to open an account. Since LLP is a mix of partnership and a company, LLP is a corporate person and it does not dissolve it if a partner dies or resigns. So, an account can continue even with debit balance. If signatories change, a new resolution is required and partners are not personally liable for the dues. What are the documents for LLP? Account opening form is required, signature card, certificate of incorporation, LLP agreement, resolution for account opening and authorized signatories, instruction with specimen signatures, PAN and KYC documents are required. Also, what is a small LLP? So, a small LLP is LLP where contribution is less than or equal to 25 lakhs and turnover is less than or equal to 40 lakhs. So, if a question comes like what is the contribution in a small LLP? So, what will you mark? It is less than or equal to 25 lakhs. Limited company, a limited company is a legal entity which means it is treated like a person in the eyes of law. So it can open a bank account, buy property, borrow money, or do business in its own name. Though there are three types of companies, types of limited companies, which we need to understand. Number one, public limited company. It need at least 7 people to start, and there's no upper limit, and they can raise money from public by issuing shares. For example, Tata Steel is a public limited company, Infosys is a public limited company, Tata Motors is a public limited company. It can invite public to buy its share on the stock exchange. And even if a company is registered as private company and if the parent company is not private, then that company will also be treated as a public company. Private limited company, it needs minimum 2 members to form a private limited company and maximum members can go up to 200. It cannot invite public to buy shares. So there are restrictions on share transfer and they cannot freely transfer the share. For example, Bennett Coleman is a private limited company. It shares are not listed on the stock market, so there are restrictions on share transfer. Boat is a uh, private limited company. Oyo is a private limited company. So there are restrictions on share transfer. It means share can be transferred, but you cannot invite public to buy or sell your shares freely. What is a government company? So this is government company. So if 51% or more shares are held by central or state government, it is called a government company and they don't need to add the word limited in its name. One person company, it is a concept of the Companies Act 2013. One person company means to say it has only one owner or member. One more person is required to be named as a nominee in case the owner dies, and it is a private limited company. How companies are formed? They are formed under the Companies Act. The company must prepare two documents. Number one, memorandum of association, what the company can do, like the objectives of the company, articles of association, how the company will run its internal function. So, MOA is a public document, AO is a private document, and once approved, the company gets a certificate of incorporation. What are the documents required for a limited company? So, a memorandum of association, article of association, certificate of incorporation, name of director, span, if there are any beneficiaries, a list of beneficiaries, and board resolution and specimen signatures. Let's talk about the rules for operation. Cash withdrawals can only be allowed if the company gives written permission. So, only authorized persons can operate the accounts. To prevent frauds, bank allow operations only if two or more authorized persons sign together. For example, any two out of five directors may be allowed to sign a check. What happens if there is a death of signatory? If a director who used to sign the check dies, the company checks are still valid because the company is a separate legal person. When it comes to borrowing money, a trading company like a retailer or manufacturer is automatically allowed to borrow, but a non-trading company like a charitable trust must clearly mention their borrowing rights in MON and AOA. Uh, then we talk about the check handling. So never deposit a company check into personal account of a director or employee. That would be a legal violation under Negotiable Instruments Act, so under Section 131. And starting, if you, the company starting business post 2019, so after registration, the company must file a declaration within 180 days confirming that all shareholders have paid their share money, and only then it can start a business. Documents required we have already covered. Now let's move on to clubs, association and unregistered bodies. What are these? These are group of people who come together for a common purpose. Now this purpose can be social, cultural, religious, charitable or professional. For example, our local yoga group, our neighborhood music club, our resident welfare association and RWA. So they are not formally registered like a company, trust or society. Instead, they may have a written agreement like memorandum of understanding and some basic rules or bylaws. A committee usually manages the activity of the group. Let's talk about the rules for opening and operating a bank account. So the bank checks the rules to know what the committee members can do, who can use the bank account. The rules must say who is allowed to sign checks and operate the account. Any money spent from the account must be for the activities of the club and group only. Payments, if any payment is made to individual member, the bank will verify why to avoid why the payment has been made to avoid the misuse. So account rules are done. What are the documents needed to open account? Account opening form, which is signed by all committee members, signature card of authorized signatory, copy of bylaws or rules, a resolution from the committee to open the account, MOU or any document showing how the group was formed, list of beneficiaries if there are any, and KYC documents as per bank rules. So these are the documents required to open an account. A trust, what is a trust? A trust is created when one person gives responsibility of managing property or money to another person for the benefit of third person. So the person who creates the trust is known as the author of the trust. The person who has been given the responsibilities of managing the property or money or to another person is known as trustee, and for whose benefit it is managed is known as the beneficiary. For example, Mr. R give 10 lakh rupees to a trustee to be used for educating poor children. So that money is held under a trust. Here, Mr. R is the author. Say the responsibility has been given to Mr. T. So Mr. T is the trustee, and the poor children here are the beneficiaries of this trust money. The trust is governed by trust deed. The trust deed is the legal document that explains the rules and purpose of the trust. Now, let's talk about account opening rules. A bank must read the trust deed to see what the trustees can do, who can operate the account, are there any restrictions or on withdrawals, and if there are two or more trustees, they usually have to operate the account together unless the trust deed say otherwise. If a trustee dies, the remaining trustees continues the work. If all trustees are gone, new ones are appointed by the court. And trustees' personal problems are not trust problems. Keep that in mind. If a trustee becomes bankrupt or has a loan, the trust money cannot be touched. You cannot set off a trustee's loan with the uh, money belonging to trust. So trustees cannot give their power to others unless it is allowed in trust deed. Charitable trust in many states must be registered with the charity commissioner. All payments from the trust account must follow the trust deed, and checks payable to the trust must not go into trustee's personal account. The bank cannot use trust money to recover the loan taken by a trustee personally. Keep that in mind. What are the documents needed to open a trust account? So account opening form is required, which has to be signed by all trustees. Signature cards of authorized trustees, trust deed, registration certificate, trust letter and resolution showing who will operate the account. If no trust deed is available, some proof of trust existence, PAN or alternatively form number 60 and KYC for all the parties involved. Executors and administrator. So who is an executor? Executor is a person named in the will by someone who has passed away, and this person is responsible for managing the property of the person who died. But the executor must get permission from a court. This permission is known as probate before handling anything. Say if Mr. S dies and names his son Mr. R as executor in his will, R must get a court's probate order before he can access or manages Mr. S property. So this term executor is clear to you. Now let's talk about administrator. Who's an administrator? So if someone dies without a will, the court appoints a person to manage their property. Now this court appointed person is called an administrator. Say if Mr. R dies without writing a will, the court may appoint a person as administrator to handle his property. Uh, what are the important rules with respect to executor and administrator? So executor and administrator cannot give their responsibility to someone else. Account must be opened only after showing proper document like probate, letter of administration, succession certificate. Account should be used only for managing the property of the person who died. Name of the account must include the term like executor or administrator and also mention a state of deceased person's name. And money from this account must be used as per court instruction. What are the documents required? So account opening form signed by executor or administrator, signature card, will if it is available, letter of probate or administration, KYC documents of executor and administrator. Cooperative societies. So what is a cooperative society? This question will come into your mind. So a cooperative society is nothing but a group which is formed by members to carry out business for mutual benefit, like milk cooperative or a credit society. Some state restrict account opening with commercial banks, and it requires the registrar of cooperative societies permission. So one of the important rule is this. Let's talk about some other important rules like you have to check the society rules, the bylaws to know if it can open an account with commercial bank. The money must be kept in only an account approved by registrar of companies, and who can sign it? A resolution must be passed to open an account. At least two people, the president of the cooperative society and either secretary or treasurer, must sign the resolution. Account must be used only for society's activities and all legal limits must be followed like maximum balance allowed, it has to be followed. What are the documents required? Account opening form which is signed by managing committee members, specific signature card of authorized signatories, resolution signed by president and either secretary or treasurer, registration certificate, copy of bylaw, KYC document of authorized person. Government and public bodies. So these are departments like income tax, forest, railways, etc., which are governed by central treasury rules or state financial handbook. So central government governed by central treasury rules, state government as per state financial handbooks. So what is the bank's role? Bank collect payment on behalf of government, makes payment like refund of salaries, and receives challan for government fees. Then there are receipts and payments. So receipts is money is paid using challan. Treasury must approve this challan, and these challans are valid only for 10 days. Say a person depositing income tax uses a challan, which must be approved by the treasury before a bank can accept the payment. What are the payments? So government departments can issue checks from special checkbooks, but no overdraft is allowed. Checks are valid for 3 months only. Payments like tax refunds are made through checks and advice notes. Some departments like forest or local department open a special current account directly with bank. So these accounts are used for specific purpose and closed after that. For example, the forest department may open a temporary account to handle funds for a tree plantation drive. So what are the rules for government accounts? It used only for the permitted purpose. Money should come from allowed sources only. Payment should go to authorized persons only. And if the authorized officer changes, new document must be submitted, but the same account can be continued. What are the documents required? Account opening form, signature card, government order notification that allows the account to be opened and explain its purpose. Now let's talk about RBI guidelines on opening current account. So RBI introduced some strict rules to avoid misuse of current account and ensure borrowers don't divert bank funds for unintended purposes. Earlier, bank had to get an NOC from other banks before opening current account. Now the system is now replaced with a clear-cut norms based on borrower total loan called exposure. So if there are no loans from scheduled commercial banks, in that case, if the customer has no loan or credit from any scheduled commercial bank uh, or payment bank, then any bank can open an account, and this include people who have taken loan from NBFCs, cooperative banks or other non-member banks. For example, Mr. R takes a 10 lakh business loan from NBFC. So he can open a current account in any bank without any kind of restriction. And if there are loans or borrowings from bank, if a person or business has any kind of loan facility from scheduled bank or any payment bank, then some rules will apply. So there are non-fund based facilities and there are fund based facilities. So cash credit, overdraft facilities. So these are fund based facilities, and letter of credit, letter of guarantee. These are non-fund based facilities provided by bank. So we'll break the rules into two main categories. Number one, borrowers with fund-based facilities like cash credit overdraft facilities. And if loan amount is less than 5 CR, then there are no restrictions. Bank must take, but the bank must take a written undertaking that the borrowers will inform them if their loan reaches 5 CR or more. Second, if the exposure is greater than 5 CR, then only one bank which has at least 10% of total loans can open the current account, right? Then other lending banks can also open, but they can open collection account just to collect payment. And these banks must send money to the main current account within 2 working days. And no lending bank can open any current account, meaning to say the bank that did not give a loan, that bank cannot open any current account. For example, a company has a 20 CR loan from three banks. So a company, this is a company has 20 CR loan from bank A. The loan is 10 CR. Bank B, say 5 CR, and bank C 5 CR. So here bank A can open a current account, bank B and C can open collection account, and no other bank, say bank D, can open any of these accounts. Borrowers without cash credit or OD facility. So if the exposure is greater than 50 CR, then banks must set up an escrow account with one bank, usually the one managing the deal, and other lending bank can also open collection account and money must go to the escrow accounts. If the exposure is between 5 CR to 50 CR, lending banks can open current account and non-lending banks can open, but they can open only collection accounts. And if the exposure is less than 5 CR, banks can open current account, but written undertaking must be there that the customer will inform once loan crosses 5 CR. Then there are some monetary guidelines like bank must review accounts every 6 months to check if borrower exposure has changed. Daily expenses go via cash credit or OD if available, or else current account will be maintained. Uh, Term loan disbursal should go directly to suppliers, not into borrower's current account in order to avoid the misuse. And when we say exposure, exposure includes all credit, fund based, non fund based facilities. There are certain exemptions. Uh, so there are some type of current accounts which are exempted from these rules. For example, accounts for real estate projects under RERA, escrow account for payment gateways or UPI platforms, account for credit card or debit card settlements, accounts under FEMA, foreign exchange rules will apply. IPOs, FPO, dividend accounts, tax payment account, white label ATM operator accounts. So these type of accounts are exempted. And then there are project specific accounts. So bank can open current account for a specific project if no CC or OD has been taken for that project. These project must close once the project ends. So these are project specific accounts. Obtaining photographs of account holders. Bank collect photographs of customers to help with identity verification. This includes resident, non-resident, and even Padanashin women. A woman who stays in seclusion are known as Padanashin women. What are the key rules? Number one, live photograph in digital KYC is acceptable. In that case, no, there is no need for physical photograph. Do not confuse photograph with signature. A photo is not a replacement for your signature. Both are needed separately. Uh, Again, there are certain exemptions. So, government departments are exempted, local authorities, bank staff, they are exempted from providing photographs. All account operators must give photographs. So, anyone authorized to open the account must give their photo. The customer must bear the cost of photograph. A photocopy of Aadhaar or PAN card is not the substitute for an actual photograph. Keep that in mind. And one set of photograph is required. A set of photograph of two photos, one set of two photos is needed for all accounts in the customer's name. With respect to joint accounts, partnerships. So each joint account holder or partner must give their photograph. For companies, bank must collect photo of the person authorized to operate the account. And for minors, if a minor age 10 year or more opens a savings account, their photo is required. But again, uh, photograph of guardian is also required. For HUF, Karta's photograph is required. And for NRI accounts, say NRE, NRO, FCNR accounts, will study them in the units to come. From unit 8 onwards, we'll study about the foreign exchange, foreign management, and there you will see what are NRE account, NRO account, FCNR account in the upcoming units, unit 8, 9, 10. So, Karta uh, so for HUF, it's Karta. For NRA account, you are required the photograph of account holder and power of attorney holder. What if the appearance has changed? So if bank notice that a person's look has changed, drastic weight loss or something of that sort, so they can ask for recent and attested photographs. Now let's move on to the last topic of the day, legal entity identifier. This is last but not the least. So this topic is quite important. Questions do come from this topic. So legal entity identifier is a 20 character Unicode. It's a mix of letter and numbers used to identify businesses. As the name suggests, it is an identifier. It identifies businesses and other legal entities, not individuals, when they do big financial transactions. So what it does, it helps banks and regulators to track who is doing what and helps in risk management. The first question which might come into your mind is, why was legal entity identifier introduced? So after the global financial crisis, many countries realized that they lacked a clear picture of who was involved in complex financial transactions. So LEI was introduced to fix this problem by improving the quality of financial data, managing risk tracking easier. It makes risk tracking easier and creates a global standard for identifying legal entities. Who issues LEI? So LEI is issued by local operating units that are certified by global body called Global Legal Entity Identifier Foundation. And in India, it is issued by Legal Entity Identifier India, which is a subsidy of Clearing Corporation of India Limited. Now, who needs to get an legal entity identifier in India? So, companies and organizations doing large financial transactions and not individuals, they are required to obtain LEI. Bank and borrowers where the loan exposure is above a certain limit, they are required to obtain the LEI. So, say if a company takes loan from one or the more banks and the total amount is more than 5 CR, then it must get an legal entity identifier. Okay. So what is the timeline to get LEI? So if the total exposure is above 25 CR, then the timeline was 30th April 2023. If it was between 10 to 25 CR, the timeline was 30th April 2024. And if the total exposure is 5 between 5 to 10 CR, then the deadline is 30th April 2025. And where do we use LEI? uh, in derivative markets, in large loans from bank, government securities and money, in RTGS and NEFT transactions. So if there is any payment of 50 CR or more by a company through RTGS or NEFT, then it requires an LEI. When we talk about large loans for borrowers having 5 CR or more exposure, when we say exposure, it is fund based and non-fund based included. So at that point of time, you require a legal entity identifier. And for forex transactions above 50 CR under FEMA rules, you also require legal entity identifier. What if LEI is not obtained? So the bank will not give any new loans and there will be no renewals or enhancement of existing loans will be allowed. Who is exempted? So government department and agencies are exempted. Also individuals are exempted. For foreign entity, a foreign mutual fund which is registered in India as foreign portfolio investor does not have a legal status in home country. So such funds can use the LEI of the parent company that manages them. So I hope this is clear to you. Let's move on to the exercise questions now. Introduction: while opening an account is optional, not to be taken, discretionary, compulsory. Now this introduction should not to be taken. So option B is the correct answer. A minor for whom the court has appointed a guardian attained majority on completion of 18 years. B is the correct answer. Minus account can be opened in the guardianship of, it can be either a mother or father. So B, again B, mother or father. There are there should be 2% to open a partnership account in a bank. In which of the following cases an account can be opened? X age 25, Y age 17. So here Y is the minor. X age 17, Y age 16, both are minor. Subha age 30, Rachna age 16, again minor. 71, 57, both major but lunatic, so person of unsound mind. So B, X age 25, Y age 21. So this is the correct answer for this question. HUF account is to be opened in a bank where there are three major persons. So number one, Shiv Kumar is there. Number two, Mrs. Ramavati, Shiv Kumar's mother. And number three, Sharat Kumar, son, who can become Karta of HUF. So after 2005, we have seen that eldest women, female members, basically can also become Karta. But if any year is mentioned here, say before 2005, then only the eldest male member can become the Karta of the family. So here, what will be the correct answer? See, uh, after Delhi High Court case in 2015, eldest female can also be Karta, but usually it is presumed that the eldest male member will be the Karta of the family. So here, two answers will be correct. Shiv Kumar. If it is prior, if the year is mentioned that it is before 2005 amendment and before the ruling of 2015, so Shiv Kumar will be the correct answer. Again, Mrs. Ramavati can also become the Karta since the eldest female can also become Karta now. So Mrs. Ramavati will also be the correct answer for this question. Both cannot be the answer. Why? Because only the eldest member can become the Karta. So there is only one Karta and not two person can become the Karta. So you can mark either A or C. They both will be the correct answer. So let's move on to our practice questions. If anyone is curious, in book it is Shiv Kumar because it is generally presumed that only the eldest male member will become the Karta. But that's not the correct legal opinion. So eldest female member can also become a Karta. So in your examination, if there is no year mentioned, then you can also mark C as the correct answer. Let's move on to questions now. Consider the following statement regarding joint account. A joint account can be opened by two or more individuals who wish to exercise joint control over funds. This statement is absolutely correct. A joint account of resident of a NRI is allowed only if NRI is a close relative of all resident account holders. Yes, it is correct. Number third, KYC document are required only for primary holder in joint account. No, this statement is not correct. KYC documents are required for all joint account holders. So A is the correct answer here. Meena, age 55 years, who cannot read or write, wants to open a savings account at XYZ bank. The bank official explained the rule to her in her native language. She is informed that she must visit the bank in person with her passbook for withdrawal. Meena requests checkbook and she also wants her son Ramesh to operate the account on her behalf. Which of the following statement is correct regarding the operation of Meena's account? So the bank can issue checkbook. So this statement is itself correct. Bank can never issue checkbook. The bank cannot issue checkbook to Meena, but bank account can be operated by Ramesh alone. No, alone statement is incorrect. The bank cannot issue a checkbook to Meena and Meena must provide an authorization come indemnity later if you want Ramesh to operate the account and it must be operated jointly. Yes, this statement is the correct answer. Let's see statement D as well. The bank can issue a checkbook to Meena, so bank cannot issue a checkbook. So automatically this statement is not correct. Here C is the correct answer for this question. Which of the following statement regarding minors bank account are correct? A minor above 10 years can open and operate a savings account independently subject to certain conditions. Yes, banks can allow minors above for 10 years of age to to operate the savings account independently. This statement is correct. Two minors can open joint account together. Never. Two minors cannot open a joint account. On attaining majority, the erstwhile minor must confirm the account balance and provide fresh specific signature. This statement is correct. A minor is legally allowed to draw, endorse, and negotiate a check as per Negotiable Instrument Act. Yes, Section 26 of the Negotiable Instrument Act allows so. If the guardian dies while the account holder is still a minor, the balance is paid to minor immediately. No, it is paid once he attains majority. So statement 1 is correct, 2 is not correct, 3 is correct, 4 is correct, 5 is not correct. Let's see where 1, 3 and 4 lies. Option B is the correct answer for this question. Consider the following statement regarding the operation of HUF account. The Karta has authority to transfer asset for legal necessity or for the benefit of the state. Yes, he does. All adult members of the HUF are required to sign the account opening form, but only the Karta signs the specimen signature card. This statement is also correct. A declaration from all adult is mandatory to designate the Karta in HUF. The statement is also correct. So all the statements are correct, making option D as the correct answer for this question. Which of the following statements regarding the operation of a partnership firm's account are true? A copy of the partnership registration certificate is required for registered partnership. The statement is correct. Checks payable to the firm can be credited to a partner's individual account. No, incorrect. In case of dispute among partners, if one partner gives notice of stoppage of operation, all operations must be stopped. This statement is correct. Partners are not considered agent of the firm for transactions between themselves. The statement is incorrect. In case of a partner's death, the partnership firm is automatically dissolved unless stated otherwise. This statement is correct. A partner has the power to open a bank account on behalf of the firm in their own name. This statement is not correct. So statement 1 is correct. Statement 1 is correct. 2 not correct. 3 is also correct. 4 is not correct. 5 is correct. 6 is not correct. So 1, 3 and 5, option B. Option B is the correct answer for this question. What is the definition of small limited liability partnership? So where the contribution does not exceed 25 and turnover does not exceed 40. In the options C. C is the correct option for this question. Which of the following statement are correct regarding limited companies as per the Companies Act 2013? A public limited company can have maximum of 100 members. No, there's no restriction on the number of members, so there is no upper limit. So making this statement incorrect. A private limited company must have at least 2 members and a maximum of 200 members, but the number of members does not include those employed by the company. This statement is correct. A one person company can have only one member and nominee named in memorandum cannot be shareholder in the company. So a one person company can have a nominee as shareholder, but the company must only have one person. So a company must have one person. This statement is correct, and the nominee named cannot be a shareholder. This statement is not correct. So making this statement incorrect. A company in which 50% or more of the shares are held by a government or subsidiary is known as government company. This is 51%, not 50%. 51%, not 50, making this statement incorrect. And when a company incorporates, the certificate of incorporation is issued along MOA, but the AOA can only be filed after the first annual meeting. So this statement is not correct. Article of association must be filed at the time of incorporation. So this statement is also not correct. So only statement 2 is correct. The question asks for correct statement. So there must be a mismatch. So only statement 2 is correct. Option A will be correct, but again only statement 2 is correct. So statement 1 states that has no upper limit, but here so there is a typo. So public limited company can have to public limited does not have maximum member limit. So the statement should be a public limited company has no upper limit. Upper limit. All right. Question number 8. Which of the following statement is correct regarding RBI revised norms for opening current account for borrowers effective from October 2021. Borrowers with exposure to the banking system of 50 CR or more are allowed to open current account freely with any bank without any restriction. On the prima facie also you see that this statement is not correct. So this statement is not correct. The system of obtaining NOC has been replaced with more comprehensive due diligence process by the bank opening the current account. This statement is absolutely correct. Person who have credit facilities only from NBFCs are subject to the same restrictions as those with borrowing arrangement from scheduled commercial banks. No, this is not true. So this statement is not correct. Borrowers who have a cash credit or overdraft facility with any scheduled commercial bank or payments are not permitted to open a current account with any other bank. So this statement is correct. The extent of borrowing determines the nature of restrictions with specific norms for borrowers having exposure to the banking system of less than 5 CR. The statement is also correct because restrictions vary based on borrower's exposure with specific norms from different exposures. So the extent determines the nature with specific norms having exposure to banking systems. So C will be the correct answer for this question 2, 4 and 5. Which of the following statement regarding the requirements of photograph for bank accounts are correct? For HUF account, the photograph of Karta must be obtained. This is correct. A photocopy of OVD with a photograph is sufficient in place. No, this is not correct. In case of NRE, NRO, FCNR account, photograph of both the account holders and power of attorney are required. This is correct. Only one set of two photographs should be taken from a customer. This is correct. For minor account operated by a guardian, only minor photograph is required. This is not correct. Guardian photograph is also required. So 1 is correct, 3 is correct, and 4 is correct. So answer will be option C for this question. Which of the following statement regarding LEI system are correct? LEI is 15. No, it is 20. So this is not correct. In India, LEI codes are issued by legal entity identifiers, a subsidiary of CCIL. This is correct. LEI registration is mandatory for corporate borrowers having an aggregate exposure of 10 CR. So it is 5 CR or more. So this is not correct. Borrowers with exposure 50 CR or more to schedule were required to obtain LEI first before extending it to lower exposure levels. So this statement is also correct. Individuals are required to obtain LEI for conducting financial transaction above 50 CR through, yeah, this is also correct. Department agencies are exempted from LEI except public sector. This is also correct. Sorry, for statement 5, individuals are not required to obtain LEI. LEI is always required for entities. So statement 5 is not correct. Pardon. Statement 7, failure to obtain an LEI can result in denial of new sanction renewals or enhancement of existing exposures by lenders. This statement is also correct. So statement 2 is correct, 4 is correct, 6 and 7 is correct. 2, 4, 6 and 7. Option A is correct for this question. I hope you learned all about unit number 4. But again, if there are any doubts, you can always ask us on our Telegram group channel, JIB CIB Prep. Let's meet again with unit number 5. Till then, bye bye, take care, and thank you for watching this session.